Live TV Talk on your digital device, on Roku, Fire TV, and Apple TV. Download the SVP TV app right now. Check us out every Tuesday on Comcast Cable, Channel 17, 8:30 p.m. And we are live every Friday on Facebook Live, 6 o'clock in the evening. You've got a question? Our attorneys have the answer. So let's talk law with Attorney Daryl O'Neill on the SVP TV network.
Welcome to Talking Law with Daryl O'Neill. I'm your host. I got my main man with you, Jerome. How you doing?
Daryl,
man?
what's going on, man?
Man, another day in the neighborhood.
Yes, sir, man.
Man, we've been off the air for a minute.
It's been a minute.
We've been running repeats. Angel told us we're running out of repeats.
It has been a minute.
Yeah.
Glad to be back, man.
It is. So if you have a Fire Stick, Apple TV, Roku TV, the SVP TV network app, Facebook Live, or YouTube Live, you can watch us, call in right now. We'll answer any question you have.
All right.
I mean, regardless of what topic, and we're going to talk in employment law today, but regardless of what topic we're talking about, we'll answer any of your questions. So we got to give our shout outs, Jerome.
For sure, yeah.
Shout outs to California, far west coast. Shout outs to Little Rock, Arkansas. Shout outs to Memphis, Shelby County. Mm-hmm. Shout outs to Mississippi. Shout outs to Missouri.
Right.
And shout outs to my family and shout outs to your family, Jerome.
Hey, fam. Yes.
Yes. So, Jerome, wanted to talk today about employment law.
Yeah.
And here's the reason why I want to get there, Jerome. What's happening here, and we see it more in the federal government, is that employees, have worked for organizations for a while.
Yes.
And they're losing their job.
Yes.
And so the question is, do they have any rights?
What I love about this show is that we are right on top of the nations. We're feeling the pulse of the nation, and people are running scared there.
Right.
I mean, you had a job that you have given up everything for. You've put your heart and soul in it. And then all of a sudden, they'll come in one day and you're gone.
Right.
I mean, that's something like marriage type stuff.
Mm-hmm.
And so, Daryl, the fact that employment is your forte,
right.
I think this is very valid for you to take on this topic tonight and try to calm the water, so to speak.
Try to calm the water.
Yeah, so to speak.
Well, Jerome, so we have 3 different levels of government.
That's right.
So the first thing that we got to look at is, depending on where you are. And so you're in Tennessee. Tennessee is what we call a right-to-work state.
Yeah, right.
And a lot of your southern states are that way. Tennessee's that way, Arkansas's that way, Mississippi's that way. I am under the impression that probably Kentucky,
I think that's
Virginia,
correct.
A lot of those states are right-to-work states.
I think so.
And what that means in Tennessee, if that an employer can fire you for any reason or no reason, as long as that reason is not discriminatory.
And you're right there. And so another word that we use a lot of time is at will.
At will.
In other words, I can have you work for me at my own leisure, my own pleasure, as long as I want to, but I can terminate that the same way too.
Yeah.
At will.
At will. And I tell people this all the time, it's simple, man. You can come into work one day.
That's right.
And the employer can say, you kind of get on my nerve a little bit.
And Daryl, you got the orange red on today?
Yeah, you got
I got
red.
gray on.
Man, I ain't feeling red.
I'm just telling you.
Red is triggering my senses.
That's right.
So I'm firing you.
That's right.
Or the employer could come in one day, or you could come in one day, and the employer could say, you worked here for a few days, and I've determined I don't like you.
I always hinge when you. I don't know if you can say.
Actually, you
can't say I don't like you.
I don't like you.
Oh my goodness.
Yeah, I mean, because
I don't like your performance.
I don't like you.
Oh my goodness.
Because as long as I don't say I don't like you because you're black.
That's true.
Or I don't like you because you're female. Or I don't like you because you wear glasses.
And Daryl, I like that too. One thing we need to go back just a little bit and lay out the groundwork. show those things that are illegal for you to do. Like the pigeonholes you just said.
Right.
There are pigeonholes that are protected by constitutional law.
Right.
And so it's very hard for an individual to violate the Constitution.
It is, Jerome. And again, okay, so, and that's kind of how, and that's, so there's these protected classes.
That's right.
Title VII
That's right.
is the big one.
That's right.
And then Title VII is, basically, I can't discriminate against
That's
you
right.
because of your race, your sex, your age, your religion, your national origin.
That's right.
Your color.
Right.
Or for prior EEO activity.
That's right.
Now, here's where people will go around that, Jerome. Somebody will say, they were harassing me. And because they were harassing me, I have a case.
That's right.
That's not true.
That is not one of the protected classes.
It's protected,
Right.
but it's protected with something.
Right. Oh.
You have to say harassment because of my age, religion, race, sex, national origin, something of that nature. So if they harassed you because of those elements, that harassment is protected.
And there, you are so correct. And that's why we always tell clients, be very careful how you respond to any request. Right. Be very careful because what you just said then, that case is completely wiped out because they didn't tag it with one of the protected classes.
And the same thing with retaliation.
That's right, exactly.
A person will say, they retaliated against me.
Exactly.
And I'll say, based off of what? Because they don't like me. That like and dislike is not a protected class.
That's exactly right.
If they retaliated, and normally how that falls off is they retaliated against you because you were utilizing one of the protected classes.
That's exactly right.
So you filed something, and then all of a sudden they start doing something against you because you filed something. That's the retaliation.
That's exactly right. Yeah.
So you just can't come up and say they retaliated against me because I complained about, Jerome was in there talking about the Dallas Cowboys.
Right.
And so, I told him I don't like the Dallas Cowboys, and all of a sudden he just retaliated against me. Well, there's no, now the Cowboy fans would truly believe if you do something against them, that's discriminatory. Right. But there's no law to protect them.
And so there, so when we are interviewing the first meeting with a client and the attorney, it requires deep probing, and you have to ask pressing questions, and sometimes clients get the impression that you're against them.
Always. Man, I can't tell you how many times, because here's the thing, discrimination cases are extremely hard.
Oh, man.
Extremely hard.
Yes.
And so one of the things that you have to do as a lawyer that's going to represent somebody in this discrimination arena is you have to vet your client.
That's exactly right.
Because number one, not only are they extremely hard, they're extremely expensive.
That's right.
So, and we may try to talk about that. If not this show, maybe another show.
Okay.
But because they're so extremely expensive and so time consuming, you cannot just take any and every case.
That's exactly right.
So you have to vet it in. And here's where people don't realize. So if you come to work and you cuss your boss out, right? But your boss don't like you because you're black, but you cussed him out, right?
Right.
That gives him a legitimate reason, even though he's a racist.
But it's on the back end, though, Darryl.
It gives him what happens is it gives them a legitimate, non-discriminatory reason for their action.
For having let you go.
Yeah.
And that's just subordination.
Subordination.
Right.
Yeah.
That's right.
So you have to, just because you get protected under this rule.
That's right.
Doesn't mean that you can violate another rule.
That's exactly right.
And the other thing that people don't realize is, one of the questions I'll ask somebody, I'll say, well, who hired you? We'll say, well, John hired me. Well, who fired you? Well, John fired me. That's not a good discrimination case.
Right.
Because if John wanted to discriminate against you, guess what? John would have never hired you.
In the first place.
He would have never hired you.
I never thought about that,
Yeah.
Darryl.
So
you're right.
Yeah. So John, now if you say John retaliated against you because you filed an EEO claim against John, that's different.
That's interesting. Yeah.
But if you say John found out that, my age, or John can see that you're a male.
I like that.
John can see that you're a female.
Right.
He can see that you black, white, or green.
Right. I like that, Daryl, because what has to be demonstrated is that a similarly situated individual who was in the same situation that you were in was treated differently from you.
Right.
Okay. So I clocked in late. I came back from lunch 10 minutes late. But the white dude came back 20 minutes late, fired me, but he's still working.
Still working. Again, those are your parameters.
That's right.
And so that gets you in the door. That doesn't get you a home run.
True.
And here's what people don't understand. And, I've had cases where I have proved discrimination.
Mm-hmm.
And then the first thing the client will say, well, man, I get more money because you proved it. No. Again, you cannot get put in a better position you would have been but for the discrimination.
That's right.
So if you lost your job, the reward or the winning is getting your job.
That's right, exactly.
If you lost pay, the winning is getting paid.
That's right.
If you lost a demotion, the winning is getting promoted.
That's right.
I mean, so you get what you have lost.
Yeah.
You can't get more.
Right. But for this particular act, I would have been here.
Exactly.
And so what happens is to place you there would give you the full recovery.
Exactly.
Because you can't get a windfall over the conduct.
Right.
So
and those are the damages, and those are the things that people struggle with. For instance, I'll tell somebody, well, they're entitled to a set-off.
Mm-hmm.
And they say, what does that mean?
Right.
I said, well, that means that if you go somewhere and work, which you're required
You're required to.
If you go somewhere and work.
In other words, you have to mitigate your damages. You can't just sit around the house, smoke weed, and watch TV.
And then say they're going to be responsible.
That's right.
Now, there's some nuances to that.
That's right.
But the point of the matter is, the law requires you to mitigate your damage.
That's right.
So if, obviously, if you are a doctor and you got wrongfully fired because of race or discrimination, they don't expect you to go work at McDonald's.
That's exactly right.
But they do expect for you to try to apply for different jobs as a doctor.
That's right.
Now, if you don't get any jobs, then those are your damages. Or you get a job that makes lesser than you would have made, those are your damages.
Yeah.
Now, the employer gets a set-off. So if you make $5, they owe you $10, then they get a difference between what you made and what they owe.
Exactly.
So if they owed you 10, you made 5, they're only required to pay you 5.
That's right. That's right.
Well, then people will say something like, man, why are they getting the benefit of me working? That ain't mine. That's the law.
That's right. That's the law.
I can't control it. That's the law. And the law says what it says. I mean, if we're going to change the law, you got to give it to your legislators and things of that nature.
Exactly.
But that's the black letter law. We're stuck with that. So I try to explain all of those things on the front end. Because now those are the obvious laws.
That's right.
There are other laws out there that will protect you. For instance, freedom of speech, your First Amendment law. But then here's what happens. First Amendment law can never overcome the company. So you can't be out on the company steps saying they're pieces of junk and nobody should go in there and work, and then you go in there and clock in and start getting paid.
Or you work for a food place and you call their food garbage.
You have a First Amendment right.
That's right.
But it only goes so far.
Don't nobody come and get this. This is garbage.
This is garbage.
So yeah.
So you get that.
That's right.
The other thing is the Family Medical Leave Act. They can't discriminate against you because you've taken family medical leave.
Right.
That's a protection. Whistleblower. And this is a big one.
Wow.
Whistleblower means that I have complained about the company or the company's conduct. Now, here's where everybody goes awry. Man, I told them that they did all this stuff, and so I did a whistleblower. No, you didn't.
No, you didn't.
A whistleblower has to be made outside of the company.
Right.
So you have to go to a third-party entity that could affect the conduct of your company. And if you don't do that, that's not a whistleblower.
That's right.
So those are some of the other laws that kind of give you some additional rights.
And also too, Daryl, these rights that we're speaking of many times are only with federal employees or governmental employees in order to get these rights, because private employers don't necessarily have to follow the same rules.
Well, the short answer is they actually do.
Okay. Okay.
And so what ends up happening is each one of those have different triggers.
Okay. Okay.
Obviously, if you have one or two people, the EEOC doesn't apply to them,
Okay.
because you got to have at least 10 employees.
Okay.
You know, or if you have, you know, so you got to have.
And that's what I was trying to do, trying to show that there are some limitations.
Yeah, there are some
to it, right?
Yeah, so they got to have the requisite number of employees.
That's right.
To be able to trigger some of these federal laws. But, you know, and the same with, you know, the Tennessee Human Rights Act.
That's right.
That's what they protect you under the state statute. But you got to have a certain number of employees.
That's right.
To make that happen. Like the workers' compensation statute. You know, they say, you know, well, I got hurt on the job, but there's only 2 people that work in your company. Guess what? Workers' comp doesn't apply.
That's
to
right.
them.
That's right.
You got to have, there's numbers they have to hit the trigger in order for those things to happen.
Exactly. And also, too, the first, I mean, there are rules on how you even began this process.
Mm-hmm.
And then that first one is that you must make a complaint with the EEOC in order to what? To begin the process. Is that right?
Potentially.
Yeah, okay.
So, yeah. So if you want to be in federal court, the only way you can get in federal court is you have to hit your administrative triggers.
Okay.
And so if you're in federal court and you believe you're discriminated against, you have to go to the federal EEOC.
Okay.
And get a right to sue.
That's right. That's right.
That's
That's what I
you
was
in
trying to get
federal
to.
court.
Right.
Now, but the federal court, the EEOC doesn't cover family medical leave.
Okay.
They don't cover the Fair Labor Standard Act. They don't cover the whistleblower statute.
Okay.
So those are not covered.
Okay.
Under the EEOC, First Amendment, those are not covered.
Okay.
So because those are not covered, there's no triggers there.
I got
you can
you.
automatically go in the federal court
I got
because
you.
there's no
Okay.
trigger.
Okay.
For instance, if you're saying that, you know, we joked about this not too long ago. If I say that you have done something to me because of my race, then 42 U.S.C. 1981, which is your Civil Rights Act, allows me to get in the federal court, you know, based off of race.
Okay.
If it's a constitutional about 1st, 15, 14, whatever, 42 U.S.C. 1983 allows me to get in court.
Okay.
You know, state action, I got to prove that the people that, this is government.
Right,
now.
right.
So I got to prove state action, the government is using their power
Right.
against me, which triggers 1983.
Right.
So, I mean, there's other ways to get in there, you know, but in Tennessee, they have what they call the Tennessee Human Rights Act. And under the Tennessee Human Rights Act, you don't need a right to sue letter. You don't need anything.
Is that right? Okay.
The statute says I can go to court at any time as long as I go within 1 year under the Tennessee Human Rights Act.
And that's the statute of limitation.
That's the statute of limitation,
Right.
1
Okay.
year.
All right.
Or 1 year from the time that you file a claim with any one of these triggered in administration.
I got you.
Or you can go right into state court. Can't get into federal court, but you can go right into state court.
Okay.
So, you know, the state statutes have these paralleling statutes in the federal government. Now, those are all if you're a non-governmental employee.
That's right.
These are the laws. These are how you get protected. If you're a state employee, let's work slowly up.
Okay.
If you're a city or a county employee, which is a government, or a teacher, which is a local government,
Okay.
they have statutes that gives you a property interest in your job.
That's right. Yeah.
So in order to fire you from those jobs, they have to give you due process, give you a hearing, give you an opportunity to respond, and then they got to put on evidence to prove that you have done some violation. That's city, county, school.
Okay. Okay. Yeah.
Now, if you work for the state government, the same thing. They have to give you due process, an opportunity to respond, a hearing, and they got to prove that you've done something wrong. That's state government. Bingo. Federal government has something the same way.
Same way. Yeah.
Got to give you an opportunity. They got to give you a hearing, an opportunity to respond. But what's great about the federal government is they have a two-pronged test. So the first one, they got to give you a hearing, an opportunity to respond, and that's what's inside the government. If you don't like the results, you can appeal it to what they call the Merit System Protection Board, and you get a brand new hearing starting all over, and the government has to prove that you should have been fired.
And that's where John was, wasn't it? You know, he died recently. Your friend.
John Walker?
No, John Horn.
Oh, John. No, John.
John,
John, that's my guy.
Yeah, John Horn, yeah.
John worked for the Memphis, he was a civil service.
Civil Service Commission, yeah.
And that's on the city level.
Okay. Yeah.
And the county has what they call the Shelby County Merit Board.
Okay.
Which is their level.
Yeah.
And the school board, actually, they hired administrative hearing officers to oversee these matters, and then it goes to Chancery Court and so on and so forth.
Okay.
So there's different bodies that oversee them, and the state have what they call the administrative law judges that oversee them.
Right.
And so different bodies have different ways these cases are handled, and then you get different ways to deal with them.
So ultimately, you could wind up in Chancery Court, and Chancery Court could overrule any of these bodies who come out with the not federal, the state things. Chancery can overrule anything that comes out of one of these hearings.
Right.
That's that they determined was not
correct.
Okay.
Yeah. So they have, and again, we're getting a little technical, but what ends up happening is you get a chance to review the decision of all these bodies.
Okay.
Even in the state, if you don't like the ruling of the state administrative law judge, you get a chance to appeal it to the Chancery Court within your area.
Okay.
And so then you get the chancellor to look at the record and determine whether or not they followed their own rules, their own regulation, they didn't violate any laws, constitution, things of those natures. And if they did violate any of those things, the Chancery Court can reverse their decision.
And you know, Darren, I was just thinking about that too. Now, it's some situations where they're not allowed to replace their judgment for the group's judgment.
Right.
And so, like you said, it's only the technicalities that would determine whether they follow their own rules or not. And so, just because the chancellor feels as if I would have ruled this way, that's not valid.
There's only one scenario where that's valid.
Okay.
And I think the Court of Appeals consistently gets this one wrong.
Okay.
And that is the school board. No, I'm telling you, because I've been on the other side of it. They consistently get it wrong. I mean, because that is the one time that the standard is different.
Right. Okay.
So in Chancery Court, for civil service or for the Merit System Protection Board, it is a review.
Right.
Okay. And basically, there's 5 things that you have to establish that they did wrong, one of those 5 things, and then the chancellor can reverse. And only if the underlying violated one of those 5 things.
Right.
But if it's a school board case, it's de novo.
Oh.
It's de novo.
Oh, okay.
So there is no presumption of correctness.
Wow.
But what happens is the Court of Appeals have a tendency to conflate the UAPA with the tenure statute.
I got you.
And because they do that, they forget that the chancellor has a de novo review with no presumption of correctness, and he can substitute his judgment.
I got you.
He or she can substitute his judgment, where they can in all these other ones.
I got you. Wow.
You know,
That's
so
interesting.
but the Court of Appeals a lot of times, because when they see these writ of certs or they see these petitions for judicial review, they kind of get locked into, you know what I call the standard judicial review, which is I cannot substitute my own judgment.
Right, my own judgment. Right.
Where that is not the same for a chancery. A school board matter.
I got you. And so there are 2. So now that we're moving on a little bit further, so the first step in one of these state matters would probably be an unemployment review, wouldn't it be?
No.
I mean, somebody, if you fired on your job, and you apply for unemployment. Wouldn't that be maybe your first step or something?
So there is a statute that says that a decision from the Unemployment Commission cannot be considered in these administrative type hearings.
I got you.
So no, it's not a requirement, it's not a necessity. What you could do is you see, if you really play your thing, you could cheat.
Right.
And what I mean by
you could use the information. That's what I was trying to get to.
You can use the testimony.
That's what I was trying to get to.
So if you can get somebody to say something that you can use,
Right.
that's sworn testimony. And sworn testimony can be used anywhere.
In the transcript.
In the transcript.
you can get somebody to say something different. And the chancellor can overrule an unemployment decision.
And they can't. But again, it gets the same. He can't
It's the same
substitute his
review, yeah.
he can't substitute his judgment.
I got you.
It's got to be one of those 5 areas, you know. And if it's one of those 5 areas, then he or she can reverse.
And you know, Tennessee is one of the states who has something unique called Chancery Court.
Yeah.
Many states don't have that.
Right.
But Chancery Court is a place where you don't necessarily have to use the law,
Right.
because it can be determined what's right and what's wrong.
Right.
Sometimes, but there's something that judges say that right and wrong, but it still follows the law.
Right. Yeah. They say
How
even
they
though
say that there?
even they say the Chancery Court is a court of equity. Equity follows the law.
Equity follows the law.
Yeah. That's what a lot of chancellors have a tendency to
But
say.
you know, and many times it's difficult to get our clients to understand how something can look so wrong on its face there, and they still come down and rule that way, because the law can be harsh many times.
Right.
And so, but you can only get the chancery on certain type of cases, right?
Right. So where it goes awry, now here's what most people don't know is those petitions for judicial reviews can be done in circuit or chancery.
Okay.
You can do them in either way. Now, personally, I'm almost always do mine in Chancery Court because there's a way I like to do these, and Chancery Court is the best way to have those seen. Whereas in Circuit Court, they're not doing a lot of these writ of certs. And because they're not doing a lot of them, they don't have that they don't have that comfort.
Right, right.
You know, and so you can get there and really get something really confused.
Right.
And really get it really, because, you know, the difference is there's 3 chancery courts.
Right.
There's 3.
Right.
And then you got 8 now, 8 circuit courts.
Right.
And so if you have 100 writ of certs and 3 chancery courts, that means they've seen them 33 each.
All the time. They've
seen them all the time.
Right.
If you have 100 in circuit court, I've only seen it 5, 6, 7, 8, 10 times.
That's right.
So my time, it's so infrequent, you know. It ain't like a divorce case.
That's right. Exactly.
It's not like a jury trial case.
Yeah, exactly.
Because, you know, Chancery Court, you can try a case in a jury trial, but you probably wouldn't want to.
Right.
But in circuit court, that's primarily your jury trials get there all the time.
And there, you know, that's interesting too, because remember, it's just like anything else. The more you do it, the more comfort you develop in there. And sometimes you can become an expert in an area simply because I've done it so many times. People say, I can do this with my eyes closed. Well, that's what you're saying now about this particular type of writ. Chancellor sees it all the time.
They say it all the time. Your writs, your injunctions, and things of those nature, a lot of those go to Chancery Court. You know, when the people are declaratory actions, a lot of times those are in Chancery Court because people are trying to get them moving a lot faster.
That's right.
You know, I mean, I make a joke, and I say this to chancellors a lot, or judges a lot of people a lot, you know, when they start talking about administrative rulings and writs of cert, I said, I don't know what somebody's telling you, but if I don't know the law in that area, nobody knows the law in that area. I said, if you Google writ of cert, I guarantee
your name is there.
You'll see, if my name don't come up 25 times, something went wrong. Right. You know. So, but anyway, again, it is not being flippant.
No, but
it's being,
you're great.
I know what the law is in these areas,
That's
and when you start saying that, oh, that's not the, it is the law.
Right.
You know. But anyway, all right, y'all. We still want to give you a little bit more. Man, you're getting free call-ins on these. I don't know why y'all wasting these opportunities. Anyway, thank you for watching the show. We'll see you back next week.